we can make the webinar slides available as well. So let me tell you, that's me. I'm a partner at Cohen Seglius. I'm a member of the Construction Contract and Risk Management Group, and I chair our commercial litigation and insurance coverage groups. And what I want to talk about today are the following topics. And we're going to move pretty quickly because we have a lot to go through. So hang with me, pay attention, it's important. First thing, we're going to talk about why insurance requirements are so important. We're going to go through the basics, and I mean basics, of a commercial general liability coverage, meaning what is this? You see this CGL, commercial general liability, what the hell does it cover? We're gonna go through that. And then I have a top 10 of insurance requirements that I see that are included in construction contracts. And we're going to go through my top 10 and what they mean, so that when you see them, you have a better understanding, hopefully after today, what the hell they're talking about. Okay? All right. So why are insurance requirements so important? As I always say, construction projects are dangerous. And it starts out from the way I think of it is the owner. The owner is responsible for injuries that occur on its property, but it's not in control of the project. Either its construction manager or its general contractor is. And because of that, it wants to shift the risks associated with the project to the general contractor or the construction manager, who does in fact control the site. And the owner doesn't want to just rely on the financial wherewithal of the GC or the construction manager to protect things. It wants the financial backstop provided by the GC's insurance companies. So that's the risk starts from the top of a project that the owner has as the property owner, and the property owner wants to push that risk down to its general contractor. And then the general contractor needs to push that risk that it's assumed from the owner to its subcontractors. So not only does the owner want the GC to have insurance coverage, but it wants it to have appropriate insurance coverage for the risks associated with the construction project. And obviously, different projects have different risks associated with them. Building the Comcast tower is significantly more risky than doing a office fit out, for example. So the insurance requirements really have to be tailored to the project. And then from the GC's perspective, tailored to the actual trades subcontractors that it's using. So one of the key things that the owner is trying to do with regard to the GC is to obtain coverage under the GC's policies pursuant to additional insured status. And that's something we're going to talk about near the end of the presentation. Meaning the owner wants to not only be protected by its own insurance program that it has to insure itself and the risk associated with the project, but also to obtain coverage under the GC's policies. And you do that through additional insurance coverage. We also do it through indemnification, but we're not talking about indemnification today, just additional insured status. Now, the GC, as I said, who's assumed this risk from the owner, wants to protect itself from liability. And it does so by pushing that risk down to subcontractors. Because just like the owner isn't in control of the project, the GC, although from a legal standpoint, has a responsibility for site safety on the project, it can't be everywhere at all times, and it's got to rely on its subcontractors to be safety conscious and do the right thing. So what the GC does is it pushes that risk, it's assumed from the owner, and it pushes it down to the subcontractors. Now, I assume we have probably owners on the phone today. We have folks who are GCs or construction managers, and we probably have more than anything subcontractors. And you know, when it comes to risk management, the you-know-what flows downhill, starts at the top and ends up at the subcontractor basis. So a lot of that risk is being pushed down to subcontractor. And if you're a subcontractor, you see that day in and day out in terms of the insurance requirements that you're being asked to agree to or obtain. So a CGL policy. What does a CGL policy cover? In the most simplistic sense, it covers claims for personal injury or bodily injury, as talked about in a policy, in property damage arising from the negligence of an insured. And that's important because it doesn't cover economic damages in and of themselves. Perhaps if the economic damages arise from property damage, there can be coverage, but think of it most simply as personal injury, somebody gets hurt, property damage, something gets broken, okay? And that's kind of what goes on in construction projects. People get hurt and things get broken. And the coverage that it provides, and this is an important point, is not only for ongoing operations. And when I say ongoing operations, what I'm referring to is the work that you're doing while you're on a project. That's your ongoing operations. So if you get sued because if you're a GC and a subcontractor's employee gets hurt and sues you while the employee's working on the project, that's going to be covered under your ongoing operations portion of your general liability policy. But your CGL policy also provides completed operations coverage. You'll often see it as products completed operations coverage. And what that means is you have coverage for a claim that arises from work that you have completed on a project. Good example, you're a mason, you put in a set of steps at a building. 3 years later, someone's walking down those steps, the project's long done, it's 3 years afterwards. That the building's been turned over to the owner, someone slips and falls on those steps, and they bring in some engineer and they take a look at it and they realize that the steps weren't built to code. And you end up, your company along with the GC end up getting sued. That claim is going to be considered a completed operations claim. And this is a key point. It's not the policy that was in effect at the time that you did the work isn't the one that provides coverage for a completed operations claim. It's the policy that's in effect at the time that the incident, the fall, takes place. Okay, it's important to understand that. Remember, not the policy that was in effect when the work was done, but when the incident or the injury took place. And that means that when you're an insurance company and you issue a policy to a contractor, you're not only issuing a policy that provides coverage for any work that the contractor does while that policy is in effect. Also, you're issuing a policy that provides coverage for anything that happens during that period of time the policy is in effect that relates to any other work that the contractor has done. All of those sets of steps that you built during the whatever years prior to getting the current policy. And I'm just I see a email here, a question. I'm going to see if I can answer it. And you know what, I'm going to have to answer this one, Terrence, at the end. And if I don't get time to answer it, we can certainly talk about it. So what else does a CGL policy cover? Remember, personal injury and property damage claims involving the negligence of an insured. And part of that is it provides the defense to the insured, meaning if you get sued, they pay for the lawyer and the resulting litigation costs. And if you've ever been involved in litigation, you understand how valuable that is, because oftentimes the amount spent on the lawyers, and this is an indictment of the profession, can sometimes be more than the actual ultimate settlement or verdict. Litigation is very expensive. And having a policy that provides coverage for litigation costs, the defense costs, the lawyers, the experts, court fees, deposition transcripts, that is very, very valuable. So policy provides coverage for the defense, but it also provides indemnification for covered claims. And what does that mean? It's going to pay for the settlement or the verdict. So if you get sued, and it's covered, they're going to hire a lawyer for you. They're going to pay the cost of the litigation, including the lawyer. And then when it comes to settling the case, or if it goes to verdict and there's a judgment against you, they're going to pay whatever monetary amount it takes to either settle it or to satisfy the judgment up to the limits of the policy. So that's what a CGL policy covers. How about what it doesn't cover? Well, a lot. There are many, many exclusions in a policy. As I like to say, the coverage grant is one paragraph, and then there's pages and pages of reasons why they're not going to provide coverage for you. In basic sense, CGL policy doesn't provide coverage for the contractor's own faulty workmanship. You put a roof on that's defective and blows off, they're not good. You don't have insurance to pay to put the roof on. That's your responsibility. There's no coverage for a breach of contract claim. Really, the claim needs to be asserted in negligence. When a claim is inserted for a breach of contract, it's very difficult to trigger coverage under a general liability policy because there's a contractual policy. No breach of warranty. Your CGL policy doesn't provide coverage for a breach of warranty. And all those sort of consumer protection-like claims, if you do any residential work, UTP, CPL, unfair trade practices, consumer protection law in Pennsylvania, or the Consumer Fraud Act in New Jersey. You're not going to have coverage for those. Now, just as an aside, if there is a claim that's covered, meaning they sue you for negligence, but they also assert breach of contract and breach of warranty and unfair trade practices. If you're in Pennsylvania, I would refer to it as in for a penny, in for a pound. If there's one covered claim in the complaint, and they look at the complaint, and carrier looks at the complaint to make the determination, what will happen is that they will provide a defense, not indemnification, but a defense for all of the claims. So if you trigger coverage on one in Pennsylvania, you get coverage on all of them. Different in New Jersey, they only will provide coverage and defend covered claims, although there's some negotiation that you can do in that regard if that situation arises. A GL policy doesn't have coverage for pollution, professional, or auto claims, or claims brought by an employee. If it's a pollution claim, the GL carrier is like, go to your pollution carrier. Professional, go to your professional carrier. Auto, you have an auto policy for that. Employee, that's workers' comp and employee liability policy. Okay. So that is why insurance requirements are important and what coverage and what isn't covered under a general liability policy. Let's start the countdown. And I got to tell you, I put them in numerical order, and I guess I am counting down to the most important one, but you kind of get there in the middle, and you know, it's all subjective. So they're all important in my mind. Some may be more important than others. So first one is the forms matter. What do I mean by that? Let me give you some examples, and a lot of the things that I'm going to be referring to here are from, if any of you have worked with me and I've helped you prepare your insurance requirements for your subcontracts, or otherwise work with you in terms of insurance and indemnification, you're going to recognize some of the things that are quoted here. Here's an example of something from my requirements. Coverage should be provided pursuant to Form CG0001-1204, issued by the Insurance Services Office, which is called ISO, or its equivalent. What the hell does that mean? Well, CG0001 is a coverage form that refers to, at the top, commercial general liability coverage form. It's promulgated by ISO, the Insurance Services Office, and it's a standard industry form. ISO is sort of the industry leader for promulgating forms used by carriers. Not all carriers use their forms. There's something called manuscripted forms in which carriers make their own forms. But oftentimes when you're looking at insurance requirements, you'll see references to ISO forms because they're the standard. So the CG0001 is the commercial general liability coverage form. And then the last four digits that you see, 1204, is the year and the month, 12 being the month, 04 being the year, that form came into use. That was started to be, was promulgated by ISO. It might take some time for carriers to adopt them, but when you're looking at the form and you see the last 4 digits, that's how long it's been in existence. And if you're curious as to what this form, when you're looking through insurance requirements, you're like, what the hell does that mean? You can put it into, as I like to say, the Google. Just type in CG 00011204. An example and sample form will almost invariably pop up, and you can take a look at it. Here's another example, and this is the second example here is from additional insurance requirements that I have. Each liability policy listed above, other than workers' compensation, employers' liability insurance, and professional liability insurance, and they're excluded because you can't have additional insurance coverage under those typically. Definitely, sometimes under professional liability, but very, very rarely. Shall contain coverage for additional insureds pursuant to endorsements CG 2010-07, 04, which is ongoing operations, and CG 2037-07-04, completed operations. And I often will put in or their equivalent. And these, you'll see the forms referenced in additional insurance requirements because whoever is demanding, if you're a GC pushing that risk down, you want to make sure your subcontractor has that particular coverage, because what you will find is that the typical forms that are added to policies by carriers for additional insurance coverage vary widely. And you want to, when you're pushing those risks down, you want to make sure you're getting what you want. And importantly, if you're a subcontractor looking at those requirements, you need to make sure that you have what they're demanding. And if you don't, then you need to figure out what you're going to do about it. So that's understanding forms. You can tell the date of the form by the last 4 digits. And the reference to ISO is the standard form. And that's what typically you're only going to see in insurance requirements. Number 9 in the countdown, certificates of insurance. So a lot of people treat insurance certificates as if they mean something, and they really don't. And it's important to understand that. If you look at the standard Accord 25, 2016-03, and there's a bunch of different, the Accord forms are, that they'll have a date at the bottom as when it was promulgated. I think the most recent one is 2016-03. It has this information on it. This certificate is issued as a matter of information only and confers no rights upon the certificate holder. Remember, the certificate holder is who's the certificate's issued to. It's down there at the bottom left-hand side of the certificate. The certificate does not affirmatively or negatively amend, alter, extend the coverage afforded by the policies below. The certificate of insurance does not constitute a contract between the issuing insurer's authorized representative or producer and the certificate holder. I mean, they could just say, if they wanted to summarize here, this certificate means nothing. And it really doesn't. You get a certificate of insurance that says that you're an additional insured. You might be, you might not. I've seen certificates that are issued by brokers that are completely incorrect. And remember, most certificates, other than very limited, I think Federated Insurance Company issues their own, but almost all certificates that you receive are going to be issued by the insured's agent or broker, and that's important to know. So the COI is not the end all and be all of confirming that you have the right coverage. It's just a snapshot in time. And even if it's accurate, it just means that at the time that it was issued, this is the coverages. And you'll see the listing for the general liability policy, what the limits are, the name of the carrier. Same with an umbrella, if they have umbrella, auto, and workers' comp. It'll have that information and the limits on it. And there'll be a bunch of boxes checked or not checked. And then there'll be some information down at the bottom in the description that is something that you typically is being demanded of the subcontractor, whoever the contractor is who's having the certificate issued for them. And remember, you're relying on that agent's broker's knowledge of the client's insurance program. And I work with some very, very good brokers and agents who are very sophisticated and really understand. And I also see ones that have no idea what the hell they're doing. That, you know, they do a lot of different lines of business. Contractors is one of them, but they don't have the expertise, and they don't really understand the coverages that they've obtained, and they don't know what the hell they're doing. And if you have one of those agents and broker, your life is going to be much more difficult than if you have someone who's good and knowledgeable. One of the things that I recommend as to COIs, and those of you who work with me know this, I like to use an exemplar or a sample certificate of insurance with the form contract. And meaning that in your form subcontract, you have what the COI is supposed to look like. The coverage limits, the different coverages, what boxes need to be checked, what it needs to say in the description. And then I like to require that relevant attachments, we'll talk about that, additional insured, primary non-contributory, waiver of subrogation, that they be attached to that COI. And that's not, look, it doesn't guarantee you're getting what you want, but at least it makes the broker pay attention. And another thing in terms of best practices, I like to put all of the indemnification, insurance requirements, and waiver of subrogation all in a single exhibit that can be pulled out of the contract easily and sent to a broker for review. Because remember, if you're a GC or an owner and you're demanding insurance requirements, you don't want to play hide the ball. These are the requirements that you want. This is what you want them to obtain, and you want to make it easily accessible to them in order to provide to their broker and be able to have the broker say, you have this, you don't have this, we have a problem, you don't have the limits, you don't have $5 million worth of umbrella coverage, you only have 3, or we don't have this additional insured type of endorsement, you have this. And that allows you, if you're a subcontractor, to then negotiate those requirements so that what you have is hopefully accepted by the GC. And you're not in a situation where you promise something that you can't deliver, because you do not want to be in that situation when you're don't get the coverage that you were supposed to. Very bad. Here's a sample from my insurance requirements as to what I require for COIs. You can see the reference to in the form set forth in the exemplar attached as exhibit as Appendix 1. That's the COI. Then I asked for the COI to have required endorsements referenced in this exhibit, and waiver of subrogation, and some other things as well. So I like to put a detailed COI requirement and include, as I said, that sample, that exemplar. So at least when you get that sample, your folks in the office can compare it to what it's supposed to look like and see if there are any differences. And if you see something that's not consistent, then you know the broker didn't look at it, the agent's not paying attention, somebody's not paying attention to ensuring that the subcontractor has the requirements that you want them to have. And it's similar if you're a subcontractor and you're required to have a certain of COI example that's being provided in the subcontract, and your broker doesn't provide that, you need to have a conversation with them about why they're not doing that. Cancellation notices, another thing that I see and I include it as a requirement. And here's my requirement. Should any of the above policies be canceled before the expiration thereof, notice will be delivered in accordance with the policy provisions. Actually, I'm sorry, that's not what I put in. That is what the, excuse me, the Accord 25 actually says. And in 2016, that language was changed to what we're seeing here. And what that means is the carrier's obligation to provide notice is set forth in the specific policy. Well, you don't have a copy of the policy, so how do you know what the policy says about sending out notice to a certificate holder or an additional insured? Well, what I like to do is, require that the carrier include a notice cancellation endorsement. And here's some, and these ISO member insurance services organizations, they do not have, as far as I'm aware, a standard ISO endorsement for notice cancellation. So they're all considered manuscripted, meaning drafted by each carrier, not by the industry group, which is ISO, but rather each carrier has their own. And here's some examples of it. In the event of cancellation or non-renewal of the insurance afforded by this coverage part, we agree to mail prior written notice of cancellation to the person's organization shown in the schedule. And then the schedule will have, if you've made this a requirement, will have your company's name in it. Meaning if you're an additional insured and a certificate holder, your name will be on that schedule. Here's another one. This policy may be canceled by the company by giving to the insured and the additional insureds indicating on the certificates of insurance issued during the terms of this policy, 60 days notice of the cancellation, and usually if it's for non-payment of premium, it's only 10 days. So that's you can get, and when you see a requirement that says we need you to give us notice of cancellation and you have to have an endorsement, that's what those requirements are referring to, this kind of language. And here is my typical cancellation notice requirement. I do 30 days, 10 days, and then I say each policy required under this exhibit shall be endorsed to require this notification, and then it goes on. But that's the key point there is, you know, if that is a requirement that's being made of you, you need to make sure that your policies have it. And if you're pushing that, if you're being named as an additional insured under someone else's policy, if you're a GC or an owner or a sub with a sub, you want to have a cancellation provision like this. Completed operations coverage. Okay, so this is kind of a hot button issue and is becoming, I'm noticing, more hot button as we go along in the last couple of years. So you'll see a requirement like this. Products and completed operations coverage shall be maintained for a period of at least 3 years after final payment for the work. And final payment obviously is a defined term, work is a defined term. And why is this important? Well, the owner wants the GC and the GC wants the subcontractor to maintain completed operations coverage. Remember the coverage for the fall down the steps that take place several years after the project's completed, for some period of time after the project is done. And the time period requirement can really vary. My standard is 3 years, but I have seen owners demand coverage out to the statute of repose. Statute of repose is essentially a hard and fast bar that says that, for example, after 10 years after 10 years of a building being completed in New Jersey, no matter what happens, the contractor's working on that, and even the design professional can't be sued. It's 12 years in Pennsylvania. I think it's 6 in Delaware. And why this completed operations coverage is important is for additional insurance coverage. Because if I'm a GC and I've demanded that the subcontractor name me as an additional insured under those specific endorsements that I referenced earlier, I want there to be coverage as additional insured for as long as possible. So if somebody falls down the steps and the GC gets sued, along with the mason who built those steps, that I can tender to the mason's carrier and say, hey, I'm supposed to be listed as an additional insured for completed operations coverage. There's a requirement for whatever number of years. You have to defend and indemnify me. Now, I think the reality is that as long as somebody's going to be in business, they're going to have completed operations coverage, right? And if they go out of business, no matter what they promised in the contract 3 years ago, they're not getting the tail coverage. They're going belly up. And the reason they're going belly up is because they're out of business. So, you know, I like to have, I think 3 years is reasonable. Some disagree, some think it's too long, some think it's too short, but as a general rule, that's what I use. I think you get reasonable protection. And if you notice, I said for at least 3 years. That it gives you the argument, it happens 5 years later and there's an additional insured, you can still make that additional insured coverage because you said, hey, I didn't say you only had to have coverage for 3 years. I said at least 3 years. Haven't litigated that issue, but that's why that language is in there. Waiver of subrogation. All right, I run into people not understanding waiver of subrogation a lot. So let me see if I can explain it in a coherent and understandable way. The waiver of subrogation, by including a waiver of subrogation in a contract, you're seeking to limit the right of insurance carrier to pursue subrogation claims against potentially liable parties. So an example, an employee of subcontractor backs a truck into an empty parked truck of the GC, resulting in property damage to the truck. What typically would happen there is the GC goes to its auto carrier, the auto has collision coverage on it, it pays to fix the truck, and then the GC's auto carrier is going to bring a claim against the subcontractor's auto policy to recover whatever the amount of damage was. If there is a waiver of subrogation in the contract, and it's a mutual one, in this case, subcontractor and GC mutually agreed to waive subrogation, it means that the GC's auto carrier can't subrogate against the subcontractor's auto policy. Now, my position is always, if I represent the GC, I want the subcontractor to waive it, subrogation, but I'm certainly not waiving subrogation on behalf of my carriers, and I'll explain why. So typically the waiver is pushed down, but it's not mutual. Where you do see mutual waivers is for builder's risk. In the standard AIA, when you're getting a builder's risk policy is being purchased for the project, there's a waiver of subrogation. Everybody agrees to waive subrogation because the goal there is to have the builder's risk policy pay the claim for which a premium was paid for that coverage, and you don't want them coming after everybody else who might have been responsible for why that claim occurred. That's pretty standard. So the GC wants the subcontractor to provide the waiver, but the subcontractor would prefer not to. Why? Well, because in the example that I provided, the more claims you have, the more expensive your insurance is, as a typical rule. And if your carrier is able to subrogate, recover some of the cost of the claim, then it can positively impact your loss ratios and potentially make it so your premiums are not going to go up as much as they possibly could if the carrier is not willing to subrogate. You know, I've never really studied this or really seen any specific examples, but that's the general sense. If you're being asked to waive subrogation, the reason why you'd prefer not to is because you want to protect your own insurance program and have them right to go after culpable parties if it was the GC backing into subcontractor's car. Now, another requirement that's important is what I refer to as waiver of subrogation in a workers' compensation policy. Now, it's permitted in Pennsylvania, not permitted as a matter of law in New Jersey. And if you see my requirements, I always say, to the extent permitted by law, as you can see here, the policy shall contain. And the endorsement, this WC000313, that is really the universal endorsement that's used. Workers' compensation insurance is heavily regulated, and they all use standard forms. None of this manuscripted nonsense that you see in some of the in GL and umbrella and pollution and the rest of them. Usually, almost invariably, whatever the forms are in your workers' compensation are standard forms. And the form is a waiver of right to recover from others' endorsement, and shall name in the schedule for that endorsement all additional insureds. What does that mean? That means, and let's give me the GC subcontractor example. I'm a GC, you're the subcontractor. I've demanded that you include this endorsement in your policy. The reason why I want that is when your employee falls off the roof because it wasn't tied off correctly, and we're not going to fight about whose fault that really was, perhaps the subcontractor, and the employee end up suing the general contractor. Not only is he going to sue the general contractor, but he's also going to bring a workers' compensation claim, and that claim is going to be expensive. And your subcontractor's workers' compensation carrier may pay out, hundreds and hundreds, if not millions of dollars related to that claim. Absent this waiver of right to recover or waiver of subrogation, under the law, the workers' compensation carrier can recover from that third-party lawsuit, from that employee's lawsuit against the general contractor. They literally, whatever monies are going to be paid to that employee as part of a settlement or verdict, the workers' compensation carrier has a right to recover its lien. It's called a statutory lien, the amount of money that it's paid as part of that claim. And that has the effect of driving up the cost of settling these third-party suits for the general contractor. If the workers' compensation carrier for the subcontractor can't do that, it makes it cheaper to settle the case. So I always require this waiver of right to recover from others endorsement on my insurance requirements as something that's being pushed down to subcontractor, or if you're an owner, pushing it down to your GC. Okay. And here's a standard waiver of subrogation clause, that's included in my standard insurance requirements waiver of subrogation indemnification exhibit in a form subcontract. And it's basically saying they're waiving the rights of subrogation on behalf of their insureds. And if you notice in the last sentence, if any of the policy of insurance required under this subcontract require an endorsement to provide the waiver, then they need to attach it to the certificate. As a general rule, if the parties have agreed to waive subrogation by contract prior to whatever the incident that results in a claim, then the carrier will agree to do so. There are some exceptions to it. So if you see this requirement that there's a waiver of subrogation, you need to make sure that you're compliant with it. Okay. Per project aggregate. All right. So this is an interesting one, and this is an important requirement. Let me explain what it means. So this is the requirement. The limits for general aggregate must apply on a per project basis. I'd like to say, what the hell does that mean? Well, it means that the policies have to provide separate towers of liability coverage for each project. As a general rule, when you get a general liability policy, it has $1 million per occurrence and $2 million in the general aggregate. And we'll also have a completed, oftentimes there'll be a separate completed operations coverage aggregate. What that means is they will pay up to $1 million for a claim. And remember, defense costs are separate. So $1 million to either settle or to pay a verdict. And they'll do that up to a total of $2 million. So if you have two claims that total $2 million, your coverage is gone. Now, obviously you have perhaps excess coverage that provides additional limits. Well, let's keep it simple on a general liability policy. If there is a requirement that the policy's general aggregate apply on a per project basis, that means that for each project that you do, you have a full $2 million worth of coverage. And that's important as a general contractor, because when you hire a subcontractor, they may already have had claims that are going to eat up all the policy limits if you don't require a per project aggregate, a per project basis. So what does that mean? It could mean by the time the claim comes around for you, the carrier's already paid out that money and there's no coverage available to protect the subcontractor or to protect you when you're the GC and additional insured under that policy. So that's why you want the per project basis. That means when that contractor sets foot on your project, they have the full limit of coverage available under their insurance program. And I require it for CGL and umbrella excess policies, so that full tower of coverage is available for your project. And I have a little graphic here. This is, I like to think of the per project aggregate in each one of these buildings, separate tier of coverage. It's a tower of coverage for each one of these buildings or towers that were built. Okay, make sense? Number 4, flow down requirements. I hate these things, but it's something that you need to pay attention to. So what are they? Well, flow down requirements are the owner will often say, these are the requirements that I want you to maintain, GC. And by the way, you need to have all your subcontractors and their subcontractors have these same requirements. You don't see it all that often, but it is something that is included. Or you'll see something like, to the extent that the GC's requirements deviate from the requirements in the prime contract, you need to have the requirements in the prime contract, which is problematic because oftentimes you don't have a copy of the prime contract. So if you ever see that kind of language, you need to ask for the prime contract so you can see what exactly you're being required to. If there's something more stringent than what the GC is, that's being flowed down to the GC from the owner and being flowed down to you. So if you're the GC, you've got to look for a flow down provision in the contract with the owner. And if you're a subcontractor, you got to look at and look for a flow down provision in the subcontract with the GC. What do I mean by that? That means that you want to make sure that if the GC is saying not only subcontractor, you have to have these requirements that I'm requiring you to have, but also these additional ones that the owner may have. But also if you hire a sub, if there's a sub involved, you need to make sure that the sub maintains those requirements. Okay. And you want to make sure that your standard requirements also comply with the flow down requirements from the contract above. Meaning if you're the GC and you have your own standard requirements, before you let those subcontracts, look at what the owner has, what they're requiring of you, if there's a flow down provision, and make sure that you incorporate those into your requirements. I know it requires extra work, but it's important to do. And you're really looking at the type of coverages that are being required. What are the limits on the GL, on the umbrella, on the pollution, on the professional? What are the additional insurance requirements? You need to take a look at that. And as I said, the GC wants its insurance requirement of subcontractors. So the flow down requirements, they're important. Pay attention to them, figure it out. Don't just blow them off. And I see that happen a lot because it's kind of a throwaway and you don't have the prime contract. You don't have, wherever you are in the contracting pecking order, you don't have what you need to figure it out. Push it and make sure you get it, or delete the requirement. If they're not willing to give you what you need to make a knowledgeable determination as what's being required of you, saying, I'm not going to agree to that, and strike it out. Here's my typical flow down requirement that I have for subcontractors in a standard subcontract. And I got to tell you, I get some pushback on this. Truckers, trucking brokers, subhaulers, vendors, and suppliers of any tier working on performing work, and I'm okay with striking that. There's a lot of people who access a site, and it's difficult to manage that when you're a subcontractor and you may be having someone deliver to you. So I'm okay with if you're a GC only requiring that your subcontractor require its subcontractors to meet your insurance requirements. Okay, indemnification coverage limitations, number 3, and we're at 1244, so we're making good progress here. So generally, as I mentioned earlier, one of the things that you'll see in contracts is an indemnification requirement, separate and apart from the additional insurance requirement. You agree to indemnify me to do for something. There generally is coverage under a general liability policy for an indemnification obligation assumed in a contract if the claim is for bodily injury or property damage. Okay, so when you enter, if you're a subcontractor, you agree to defend and indemnify the GC for claims for personal injury and property damage that arise out of your work. As a general rule, there should be coverage under standard CGL policy. Okay, the rub and the problem is that the available coverage for indemnification varies widely, and it really depends on the endorsement that the carrier has added to the policy. And the reason is that having coverage for an indemnification obligation, it means if you're the subcontractor's insurance carrier and the subcontractor agrees to defend and indemnify the owner or the general contractor, and the owner and the general contractor are sued, the subcontractor's insurance carrier may have to, if the indemnification is enforceable, defend and indemnify that GC or owner. And that means not only is the policy having to defend the subcontractor, but also the GC, the owner. There may be different attorneys involved. It can really, really get expensive. And how have they responded? Well, they've responded by restricting the coverage that's available under a GL policy. And they do it by modifying the policy's definition of insured contract. So here is one of my requirements that I have in my standard subcontract form. The policy, and this is for, I include this for CGL and also umbrella. The policy shall not include ISO, remember that's Insurance Services Organization, the standard, the industry standard, endorsement CG 2426, CG 2139, or any other endorsement that limits or seeks to limit or change the definition of insured contract as set forth in CG 0001-1204. And that's that commercial general liability coverage form we started talking about at the beginning of the seminar. And let me explain what these endorsements do. CG 2426 changes subparagraph F of the definition of insured contract by adding the following limiting language: provided the bodily injury or property damage is caused in whole or in part by you or by those acting on your behalf. And the way I interpret that language is that it limits the indemnification coverage to intermediate indemnity or limited indemnity. It will not provide coverage for broad form indemnification. That's sole negligence. And the reason it won't provide coverage for sole negligence, because it says caused in whole or in part, it says party, but it says should be part, by you or those acting on your behalf. If the GC is alleged to be solely negligent, then there's not going to be coverage. So if you've agreed to broad form indemnification in your contract, your subcontract, and your policy has this CG 2426 endorsement, which they often do, you do not have coverage, full coverage for that broad form contractual indemnification. That is an issue, and it's something you should review in your policy to see if it's there, and make sure that you understand and talk to your broker about the implications of having that endorsement in your policy. Now, even worse than the CG 2426 is the CG 2139. That eliminates subparagraph F entirely. And what that means, there's no coverage for contractual indemnification obligation. So if you've agreed to defend and indemnify the GC for personal injury and property damage claims arising out of your work, you're shit out of luck. You do not have coverage under your policy if it has a CG 2139. That's why I put in my form subcontract. You cannot have that policy, those endorsements, subcontractor. Now, if I'm only requiring intermediate endorsement, intermediate indemnity, I'm okay with a CG 2426. I prefer not to see it there anyway. So that's indemnification coverage requirements, and that's when you see those forms and those endorsements, that's what it means. Okay, additional insurance requirements, and we're going to have to go fast on this. This is number 2. Just generally, AI coverage, when I say AI, I'm referring to additional insured. It's either scheduled or it's automatic if required by contract. And there's 2 different ways to do it. It used to be that if every time you needed to list somebody as an additional insured, you had to call your broker, and they had to call the carrier, and then the carrier had to add the issue an endorsement that said that ABC company is an additional insured under this policy. The industry moved more towards automatic if required by contract, meaning that if you've agreed in a contract to name someone as an additional insured, they're automatically included under your additional insured endorsement. And oftentimes you'll see scheduled the scheduled endorsement that rather than putting the name of whoever is going to be an additional insured, it will just say we're required to be an additional insured under contract. So they've sort of merged the 2 concepts. But there are carriers, I've seen, I know Federated will issue, they issue scheduled AI endorsements, particularly for completed operations coverage, where they will issue the endorsement that lists the entity that is being named as an additional insured. So that's the difference between scheduled and automatic. Now, different endorsements provide different coverages, and the rule of thumb is carriers have steadily been narrowing AI coverage due to the financial exposure. Just like I talked about with indemnification, the carrier, if it's insured agreed to defend and indemnify someone in the contract, that they may have to step in and defend and indemnify under the policy that GC or owner that the subcontractor agreed to do. Same thing as with AI coverage. And you may have seen the CG 2010-1185. I mean, you still see it. That is almost impossible to obtain right now. That was the gold standard for AI endorsements, promulgated in November of 1985, when I think I was a sophomore in I guess I would have been a sophomore in college at the time. So very, very old. It has something called a rising out of language. Couldn't be any more broad than that. And it provides both ongoing and completed operations coverage. If you see that in your requirement, you got to talk to your broker immediately, because you're not, almost invariably, you're not going to have that coverage, even the equivalent typically in your policy. So for owners and GCs, it's important that you know what AI coverage you're asking for and what AI coverage you're actually getting. And that's why I put a requirement that with specific references to forms, and then the COI, they're supposed to attach those coverage forms to the COI so you can compare and see if you got what you're supposed to get. For GCs and subcontractors, again, you need to know what AI coverage you're being asked for, meaning the GC from the owner, subcontractor from the GC, and you need to know what AI coverage you actually have. So that's the key here. And you really need to sweat the details on additional insurance coverage, not only in your requirements, but also whether you can meet the requirements that are being asked of you. So part of the additional insurance requirement is the primary non-contributory requirement. And when you look at additional insured endorsement, it almost always require a written contract that provides additional insured coverage be primary and non-contributory. What does that mean? You want, if you're an additional insured under a policy and you're requiring that, you want to trigger coverage under your subcontractor's policy, in my example, under their general liability policy, and you want their policy to go first, okay, before it gets to your policy. If you don't put in that coverage must be primary and non-contributory, invariably what happens is that the additional insurance coverage available under your subcontractor's policy says we're excess over any other coverage that is available to the additional insured. So you've made a request to be named as an additional insured. You didn't put in that had to be primary and non-contributory, and the result is that the requirement's completely worthless. Basically, the subcontractor's insurance carrier says, okay, if you run out of coverage, come back and we'll play with you at that point. That never happens typically. So not only you have to have additional insurance requirements, but you have to have primary non-contributory. And you, if you're a subcontractor, you need that to confirm that you can meet these requirements. If you're a GC from the owner, you have to make sure that if it's being required of you, that your policies have that coverage. I've seen many times in which the contract required it, but the policy didn't have that coverage. And then you've breached your insurance requirements, and there's arguments, depending on the state that you're in, that you stand in the insurance company, meaning that because you didn't get the coverage you were supposed to, you effectively become the insurance company in terms of meeting the obligations that the carrier would have had to meet to provide a defense and to indemnify. Not a situation you want to be in. So here's my sample AI requirement. And because we're running short on time, I'm going to go quickly through this. You can see my endorsements, the CG 2010-0704 is ongoing, 2037. I do this CG 2032-0798. It's only necessary if the owner requires an architect or an engineer or surveyor to be named as an additional insured in the contract documents. If you deal with AIAs frequently, because they're designed by or written by architects, they always have an additional insurance requirement for an architect. How an architect could be subject, would have coverage, could have a CGL type claim. Architects get sued because of professional negligence. So never quite understood that, but that CG 2032-0798 is the form that provides that coverage. And then I have a broad, so name as additional insureds. So remember, this is subcontractor. So the owner, and then I have it broadly stated, each of their respective employees, directors, officers, and shareholders. You can put in members if it's an LLC. General contractor, the same thing. And then I always have a catch-all. Any other person or entity is required by the contract documents. And the reason why I do that is that sometimes the owner has required an entity to be named as an additional insured that you didn't see or you missed, and didn't include it in the requirements. And this Romanette number 3 is intended to kind of pick that up and provide kind of a stopgap or an emergency backup in the event that you missed it, because the argument is I required anybody under the contract documents, even if I didn't identify them. And then the coverage for the additional insured under each of the policies shall be primary and non-contributory to any other coverage maintained by the additional insureds available to contribute to payment of any loss. That's the magic language to make sure that the CGL carrier for the subcontractor can't say, you go first, and then we'll pick up. Okay. Lastly, and at 12:57, we made it. My number one rule of thumb here, and it's not what is the most important requirement that you need to be aware of. It's more, have your broker and your agent review the requirements. And as I said, I've now taken to moving all of the things that your broker should be looking at. Your indemnification, make sure you have the right coverage for that. The insurance requirements, make sure your program conforms. Make sure that you have them ideally in one, if you're a GC on your subcontract, one standard exhibit that can be sent. And if you're the subcontract, make sure that you pull out the sections of the policies that have the indemnification, waiver of subrogation, insurance requirement, and send it to your broker and make sure they review it. Because look, they're the ones who understand your insurance program. I understand insurance a lot and I can review your policy, but your agent, your broker really understands what coverages you have and what you don't. And they can review those requirements and highlight to you where you have issues. And that's an invaluable service to you and something they're really important part of your risk management team. And let me tell you something. If your agent, your broker is unwilling or incapable, meaning they just don't have the sophistication to review these requirements for you, then you need to consider making a change. Construction is a difficult business. It's very, very risky. And the insurance that relates to the industry is very specialized. And you want to make sure that you have someone who knows what, as an agent, as a broker, a trusted advisor, who knows what the hell they're doing. So when you get that subcontract, not only do you review it for the terms that you're familiar with, and maybe you have some familiarity with insurance requirements, I would urge you to pull out the relevant sections, send it to your broker, have them review it, and have them provide comments to you. All right. Okay. Questions. Let me see if I have a bunch of them here. Let me see if I can read them quickly. If a subcontractor agrees to broad form indemnity and does not include the limiting endorsements you mentioned, does that significantly increase the cost of those policies for the contractor? Well, let me frame it, Joel, this way. The broader the scope of coverage you have typically under a policy, the more expensive it's going to be. The adage that I always use is, good insurance isn't cheap, and cheap insurance isn't good. So if any broker allowed a policy to insure a contractor to include a CG 2139, the one that eliminates coverage for indemnification, you need to run from that broker and get somebody else. So generally, as a rule, if you've required that, for example, they have a CG 2426, but you want to limit it because you're from indemnification, there may be, if to the extent that they can get that coverage for you, there's probably going to be an upcharge, meaning how much, I don't know, but something that can be negotiated. Okay, here's one. We're an owner developer. We often secure insurance coverage for our projects via our GC CSIP. Occasionally, our GC is not agreeable to adding us as an additional insured to their CSIP. The 1001 version of ISO additional insurance endorsements allow for coverage for an AI sole negligence. In your opinion, is the 1001 edition acceptable in lieu of coverage as an additional named insured? So that's, you know, I'm surprised that there are GCs out there that are running projects that have CSIPs and don't include the owner. Typically, the owner is included, in my experience, and the reason is because it's a benefit to the owner that makes perhaps the GC who's offering the CSIP bid more competitive. Now, if they're not agreeable to having us as an additional named insured, are you going to get the same coverage as from the 1001? Yeah. I mean, yeah. If you're able to get that 1185, that CG 2010 1185, I would feel comfortable with that. But I'm just surprised that they're not willing to list you as an additional named insured, meaning, you know, it's GC Inc. name is one of the named insureds as well as the owner. But that's an interesting question. Teresa, how can you not sign the waiver of subrogation as a subcontractor? Remember, you're not really signing the waiver of subrogation. You're signing a subcontract that has a waiver of subrogation in it. You know, how do you, if it's something that you, I wouldn't be worried about it unless it's something that you affirmatively need to obtain from your carrier, meaning that if your policies already allow you to waive subrogation, I really wouldn't sweat it all that much, at least on the GL. I can see sweating it a little bit more on the workers' compensation because that can impact your mod, although it can impact your mod because if you're able to recover some of that money that was paid out on that big claim, it would favorably impact your mod rate. It takes so long for that money to come in, and there's what, a 3-year look back. I'm not even sure if it makes a difference there. So, I mean, if you look, it's like any other insurance provision. If you don't, or contract provision, if you don't want to do it, you say no, and you see if they'll accept it or not. You know, sometimes GCs want to work with you, and they'll be flexible. Other times they're like, it's our way or the highway. I always find that when I'm negotiating for subcontractors, I'm always dealing with the my way or the highway. And whenever I'm dealing with representing GCs, there's always some reason why we need to be flexible. I always find that, I don't know why that works, but that's the way it always seems to be. Here's another question. So as an owner who needs to review insurance coverage versus the contract before construction begins, and the certificate of insurance basically is worthless in your words. Not worthless, but it shouldn't give you, you shouldn't sleep well at night just based on the COI. Is there some middle ground, that we can ask for to ensure proper coverage? Something that is less than asking for the actual policies, which are equally meaningless to owners without their insurer review. So good question. So I think what I have defaulted to is the exemplar or sample COI. So your insurance program has a sample COI that has all the boxes ticked and all the coverages that you want. And then I require the specific endorsements for waiver of subrogation, the notice requirement, and the additional insurance coverage. And I think that's a pretty good middle ground there. Now, it's going to take some work because you have to see the AI coverage that they have compared to what you've required and see if there's a difference. And I have to tell you, I mean, I have clients contact me, 3 times a week to look at COIs and additional insurance endorsements and say, hey, is this good enough? It really requires some review and expertise, and something that you may want to consider having your broker involved with, to do that review for you and to say, hey, I've required the CG 2010-07-04. They've given me the CG 2010 with a different date, 04-13 or something like that. Do I care? And sometimes the answer is no, not really. And just, a key point here, and I always emphasize is, remember, there's, when you're looking at requirements, there's the difference between insured risk and uninsured risk. You're trying to, if you're a GC, you're trying to push that risk down the hill, down to your subcontract. And the reason you're doing that is you're trying to make sure they have adequate coverage in case that they're sued, because you don't want to have to be the deep pocket. You want them to be the deep pocket if both of you are sued. You also want to see if you can trigger coverage under their policy as an additional insured. But remember, you have your own insurance program. Work for you. Well, you're not assuming an uninsured risk by waiving that insurance requirement. What you're doing is you're not protecting your own program as much as you could, and you want to, and that's the way you have to think about it. You have your own insurance coverage, you're trying to push it down. If you're a subcontractor and you're assuming an uninsured risk, you've agreed to provide contractual indemnification obligation that's beyond the scope of your insurance. Well, that's different. That's an uninsured risk. And if something goes wrong, you're writing a check. The difference between you writing a check and your insurance company writing a check. Hey, you don't want your insurance company to write the check, but I damn well prefer them to write it than for me to write it. Let me see. Okay. Terrence, getting back to you. A lot of our subs want completed ops coverage to follow the warranty period, and we sometimes have a tough time explaining the occurrence basis, and that completed ops is a separate from a 1-year warranty obligation. You're absolutely right there, Terrence. They don't have coverage for the warranty obligations, so that's like, it's apples and oranges. And that if they are liable for damages, we want their insurance to respond. Do you have a good approach to explain this to subs who review and negotiate our insurance terms? That's a great question. I think that the most effective way to illustrate it is to give that example of the falling down the steps after they've completed the building, or there's the roof leaks and causes property damage to the interior of the building. I like to think, use examples that concrete examples that make sense. That's what I like to do, because if you say to them, hey, look, if you build crappy steps and someone falls down 2 years after you've completed and I get sued because of your crappy steps, I want to have coverage under your policy as an additional insured that's reasonable. We agree, right? And that, it's hard to fight back against something that seems reasonable. So examples, I think, are a good way to go, Terrence, to explaining these. And the trick is to get a bunch of canned examples that you can quickly articulate when you have these discussions. David, you said the COI is a representation, though, isn't it? Isn't that worth something? How do we ensure we're covered then? Okay, well, that's also a very good question. I see brokers and agents issue COIs that are inconsistent with the insurance coverage. They've made representations to you that are not true. And they've said the named insured had coverage that they didn't have. Or they've said there's additional insurance coverage for the owner, when in fact the AI endorsement provides that there has to be contractual privity. So what's your remedy under those circumstances, David? I think your remedy is a negligent misrepresentation claim against the broker. If the broker issues a BS certificate of insurance that's not accurate on its face. You can make an argument that you saw that COI, you relied on that COI, and you've been damaged based upon the reliance. When you determine that, in fact, the coverages that they said that were going to be provided weren't provided under the policies. Okay. Last question here about how much does umbrella insurance cost? So good question. A shit ton right now. Umbrella coverage is very expensive. And we'll end on this. What has happened is that the model for umbrella coverage was always, we pay premiums, but we accept premiums, but we don't pay claims, because the thought was that the claims were all going to get resolved in the primary layer of the CGL coverage. What has happened in the last number of years is that we've seen more and more larger and larger claims, or bigger and bigger verdicts coming out of courts like Philadelphia Court of Common Pleas. You're routinely seeing 10-figure verdicts, and as a result of that, the umbrella layers are frequently having to pay lots, and because of that, when you have a model in which we don't charge very much premium for a lot of coverage because we don't expect to ever have to pay out a claim, and we can go into the reinsurance market and push off that risk into reinsurance, and that's why we can do it cheap. That's changed, and if you've had to renew your umbrella coverage in the last couple of years, you would have seen how hard that market is. And not only I'm seeing owners requiring GCs to have higher limits and subcontractors to have higher limits. You're a steel erector, I want you to have $10 million umbrella policy. The prices have gone through the roof. So umbrella coverage is very expensive right now, and I don't foresee it changing. And if you have the unfortunate pleasure of doing work in the New York market, especially in the boroughs, it's even crazier. I can't imagine how anything gets built in New York based upon the cost of insurance there. So thanks everyone for showing up today. I know that was a little bit of kind of drinking through a fire hose. I appreciate all the questions. Always enjoy giving these. I think I have my contact information I'm supposed to provide. There's that handsome picture again. My email address, that's also my direct dial number if you need to reach me. If you have a question, even if you haven't worked with me before, if you have a question, feel free to pick up the phone and call me. I'm sort of an insurance geek. I like to talk about this stuff. I like to feel that I'm smart. So feel free, even if you're not a client of the firm, to give me a call and see if I can help you. Our CCRM group, our Construction Contracting Risk Management group, exists to help contractors with subcontract forms, to review forms for you, to keep you out of trouble. That's what we want to do, and that's what we're trying to do. And if that means giving me a call and bouncing something off, I'm more than happy to do that. So really appreciate everyone stopping by tonight, and have a great day. And again, got a question, give me a call. Thanks, and have a good afternoon.